All right, good afternoon, folks. I hope that everyone's having a fantastic day. I thank you all for being here today for this training. I know we've had a few trainings this week. It's been basically Tuesday, Wednesday, and Thursday. So for the folks that have powered through and come to them all, thank you. And for the people that it's their first time here today, thank you. And we're so happy to have you. Welcome to Lawyering by Design, defining high quality legal representation in partnership with youth. This training is co-sponsored by Florida's Children's First, and it's presented by the National Association of Counsel for Children. Before I go into introductions, I just want to go over some housekeeping. First and foremost, this is being recorded. A copy of the recording will be sent out to all attendees and registrants. It usually comes out a day or so afterwards through an email populated through Zoom. If anybody does not receive that, please feel free to reach out to me directly. I will put my information into the chat and help you with anything that I can. Second, I enabled the closed captioning. So folks should see everything that I'm saying in a small black box towards the bottom. If anybody has any trouble or is not seeing that, please feel free to message me either in the Q&A or the chat, and I'll do what I can to troubleshoot with you. Next, CLE credit. I'm not sure if everybody was aware, but we received very nice CLE credits for this awesome training. I believe it's one general CLE and 0.5 in your ethics. There are also some certification credits as well, which I will put that CLE number into the chat towards the end of the training here today. And additionally, you will get that information in that populated email along with the recording. So, and I think the last housekeeping matter is questions and answers. Our presenters graciously are willing to answer any questions you might have, and those questions might be answered in live time if there's a moment in the presentation that permits, certainly towards the end. So we encourage you to, as your questions arise, pop them in the chat. We will present them at the time that works best for the presenters. So don't be shy, ask your questions. And thank you for being involved and engaging. And without any more housekeeping, the boring stuff, I will introduce our presenters here today. So first, we're going to have Allison Green. Allison is the legal director at the National Association of Counsel for Children. In this position, she manages the organization's policy advocacy and provides technical assistance to child welfare practitioners nationwide. She brings 15 years of child welfare experience to this position, spanning social services, direct legal services, state agency work, and national policy advocacy. Previously, she served as a Foster America Fellow at Missouri's Children's Division and as a senior supervising attorney at the Children's Law Center of Washington, D.C. Allison is an experienced trainer on a variety of child welfare topics, is a child welfare law specialist, and has volunteered as a CASA. Next up, we will have Cristal Ramirez, who is the Youth Engagement Manager at National Association of Counsel for Children. Cristal joined the team in June of 2020 as their first youth coordinator. Cristal is originally from Bakersfield, California, and moved to San Diego, California to attend school at San Diego State University. She obtained her BS in interdisciplinary studies in 3 departments and a minor in cultural proficiency in May of 2018, and her MS in multicultural counseling with an emphasis on social justice education in May of 2020. Cristal is a person with lived experience in the foster care system and is passionate about advocating for better policies and best practices for youth and families. With that being said, I'm going to turn it over to Allison, and thank you both so much for being here, and thank you very much to Florida's Children's First for helping us get in touch and put this together. The floor is yours.
Thank you, Alexis. Thank you for organizing this training. Thank you to Florida Children's First for making the connection for this to happen. And hello, Florida. My colleague Cristal and I are very pleased to be with you virtually today and share some information about the recently released NACC recommendations on children's legal representation. There was already an initial question in the chat, and I encourage you to keep them coming, about who's the right audience to just be in the room. Please be here and stay here if you are someone who works in child welfare courts in Florida. If you represent kids, yes. If you work for the GAL's office, yes. If you are a judge, yes. If you are a parent's attorney, yes. If you are an agency attorney, yes. Why? Because all of those roles need to know what to expect from children's lawyering, and many of the concepts here are actually applicable throughout the roles. But regardless, in order to be the best advocate or judicial officer and ensure high quality court hearings, you need to know what a child's attorney should be doing in their case and some of the best practices that have come forth through this process. So without further ado, I'm going to do the hardest part of the training, which is the share screen function. Please bear with me. I think we'll get it right this time. Okay. Can you all see my screen?
Yes.
Thank you. All right. So welcome to Lawyering by Design, defining high quality legal representation in partnership with youth. We're going to start off with introductions. How many of you even know what this image is? This cassette tape. Many of us grew up with these, listening to music, and cassettes have an A side and a B side, right? You used to be able to listen to one side of a tape and then turn it over, perhaps for other songs. Sometimes there was a secret song on the other side. And we're going to introduce ourselves the same way. Christelle?
Hi, folks. Good afternoon in Florida. Good morning from San Diego, California. My name is Cristal Ramirez, and my pronouns are she, her, ella. My A side, more on my professional side, as was mentioned earlier, I'm a proud San Diego State University alumna, ×2. I graduated with my bachelor's there in 2018 and went straight into a master's program in multicultural counseling through the community-based block program at San Diego State University. And shortly after I graduated in May 2020, I started my position with NACC as the youth coordinator. Now Youth Engagement Manager, where I oversee our National Advisory Council on children's legal representation, made up of young professionals with lived experience in the child welfare system, and oversee our youth engagement efforts. On my B side, you can see on the upper right corner, that is my pup. Excuse me, that is my pup named Daphne. She's 2 years old, the sweetest pup you'll probably ever meet, and in my humble opinion, the cutest pup. She's my mini best friend, my four-legged best friend, and I love her dearly. There's also 2 pictures there of being outside in the sky. The one in the middle is in Yosemite, and the one on the bottom right was Christmas morning in 2011, I believe, in Bakersfield, California. That's when I first picked up a camera, and I just was really just loved the sky. My friends tease me because whenever there's a really beautiful sunset or a sunrise, I get teary-eyed very easily, just because I get overwhelmed with how beautiful the world is, the sky, desert, anything like that. It really excites me and makes me really happy. So that's a little bit about me, and I'm excited to be here with you all today.
Thanks, Cristal. And here's my A side. This is the professional side that we typically use to introduce ourselves to the world. I'm the legal director at NACC. Prior to coming to this role, I worked in Missouri's Children's Division, working on best practices for court-involved kids in foster care. And then prior to that, I represented youth in the Washington, D.C. foster care system at the Children's Law Center. But then there's my B side as well, my personal side. I live in New York. I'm a big fan of musical theater. We were raised in my family on show tunes, love to eat. And in fact, I even have a sandwich named after me, which I'm pretty proud of. So you might be asking, why are these presenters giving these lengthy introductions with details of their lives that I may or may not care about? And that is because our human-centered designer taught us to through this process. So there's method behind the madness. This A-side, B-side metaphor is one of the first tools we used to engage in developing the recommendations you're about to hear about. Why? It was really about humanizing who we are and who we bring to this process. A lot of times we show up to committee meetings, task forces, staff meetings, you name it, and we're only showing our A side, who we are professionally, and not all of the personal pieces, strengths, challenges, baggage, bias, and like unique pieces of ourselves that really make us whole people. So the first thing that made this process fundamentally different is that we were encouraged to show up differently and bring both our A side and our B side to the role. So I'd encourage you to think about, doing the same and sit in the same as we're together today. This is a brief overview of what we're going to do in the next 90 or so minutes. We're going to provide some background on what this document actually is, the NACC recommendations, and why we came to a point of needing to revise it. Then we'll take you through the process. And then most importantly, and most substantively, the end product. What do they actually say? And what do you need to know as someone working in child welfare courts? I will highlight some challenges and also some of the really bright spots that came out. And then we'll take your questions at the end. As Robin said, if you have questions throughout, don't forget them, throw them in the chat. We'll also try to get to some throughout. So let's kick it off talking about these recommendations for legal representation of children and youth in neglect and abuse proceedings. It's a mouthful of a title. What are they? Well, this is a document that really established the National Association of Counsel for Children's organizational identity and values. It was first authored in 2001, slightly over 20 years ago, by a group of then leaders in our organization and really national leaders in child welfare law, academics, court leaders. And it established benchmarks for the field. What does high quality legal representation look like? What did they believe it looked like at that time? And those benchmarks have been used over the last 2 decades to shape and inform what the expectations are for children's lawyers, many times for better and sometimes not. When I came to NACC 3 years ago and started looking back at these recommendations and also talking to our current membership across the country, I was really surprised to see how often they had been referenced and embedded in our current court culture. For example, the prior recommendations had been cited to extensively in state legislative policy advocacy to develop budgets for children's law offices. It had been cited to, or even verbatim pulled from, to develop state practice standards for attorneys. There were attorneys citing to it in amicus and appellate cases, and it was frequently woven into the academic scholarship in this field. So that's like a really good thing to know that work that was done had been really utilized. But we also knew it was time for a change, that it was time to really revamp these. First and foremost, there had been no update to the recommendations since 2001. And so they were just plain on getting old. We know in child welfare, like 21 is kind of like a symbolic age. So it seemed even more ripe to revise now. But there was also some things in there that I really hesitated about, that were really no longer stood as true. Are there some principles in that first set of recommendations that still hold true today about the value of children's legal representation, about children's entitlement to have a voice in the cases that affect their lives and their futures? Absolutely, there are some enduring truths. But there was also quite a bit of outdated language and terminology, some paternalistic concepts that we know are no longer reflective of best practice. And all of the great research that has happened in our field over the last 2 decades was not in them. Research about adolescent brain science, trauma, mental health, race equity, all of these best practices were not in there. At the same time, our inboxes and voicemails were full with requests for guidance from the field. because, as many of you may know, there's been a big and overdue federal push for high quality legal representation for both parents and children. In late 2018, the federal government changed longstanding policy to allow Title IV e-dollars to be used to reimburse states in eligible cases for the cost of child, parent, and tribal representation. That's really exciting. And states were saying, oh my gosh, we want to use this, but we want to use this funding for impact. We don't want to use it just to fund more of the same. We want to use it to incentivize high quality attorney. So we needed to revise the document so that we could meet the moment. And at the same time, continue our push for Counsel for Kids in all states. We're continuing to do TA in the 14 states, including Florida, that do not have a universal guarantee for children's legal representation. So when I think of the old recommendations, I often think about this old bunch of bananas, like that many of us have seen on our counter. A little spotty, you can still eat them, but maybe they're not the most desirable. And our new ones are the fresh batch that we just got from the store. So where did we begin this process? We really started from a different place than NACC had ever used before, and frankly, that we're aware of had ever been used in the children's law field before. We scoped projects with various different human-centered designers. What is human-centered design? Human-centered design is a process, a protocol, and a way of thinking that is used in many other sectors to design products. For example, the airline industry uses human-centered design to decide how big or small their airline seats should be. We all know they're probably a little too small. They need to do better on that. Software engineers like Facebook and more have been using user-centered design for years to figure out, okay, if we're creating a product for the end user, how do we tailor it to them? Oddly enough, this process had never been applied to child welfare. Previously, standards of practice for attorneys in child welfare court had been developed for lawyers by lawyers, or sometimes for lawyers by lawyers and judges. They had never been designed by the client community that we were serving. Even though we know that in other aspects of law, like big law firms, that they absolutely tailor they have whole departments dedicated to client services and keeping their clients very happy. So we really tried to start off from a different place. If you want a different outcome, you have to start from a different place. And that's what we tried to do here. We engaged with a human-centered design firm called Baitna Design, who taught us from the first moment that we are all designers. So it's a word, I hope resonates with you throughout the training. I didn't really frequently use that word as a lawyer or a policymaker previously. I often said, draft this, or I would use words like, make policy or influence. But the first thing she taught us is we are really all designers. Anyone who makes decisions that impact the wellness and potential of others is a designer. So if you are a caseworker, if you are a guardian ad litem, any decision you make that is impacting others means that you too have a design role and a design responsibility. One of the reasons we chose Baitna specifically is because they didn't just take human-centered design thinking from the private sector and apply it to social issues. They added some layers, they call it liberatory design thinking. And we won't have time to go into all of it today, but really what it does is it adds an equity lens to the process that's used in the private sector. It uses a framing of equity, racial equity, gender equity, and more to try to acknowledge that we're all coming from different places and that the systems we are here to design today have actually been informed by many, many years of inequity. The symbol that you see on the right-hand side of the screen is a short summation of a very long process that they guided us through over time. And when I say over time, this process that we initially anticipated to be 1 year or less ended up taking about a full 2 years. So one of the first lessons in human-centered design is that it's slower, but we think it reaches a better and more robust outcome. In the human-centered design approach with the liberatory mindset, you're defining problems, imagining different results, and then prototyping, trying to say, how about this, and getting rapid feedback from the client community you're serving with a continual lens of empathy for the experience they're going for and reflection throughout. On this next slide, you'll see a few tools that they provided us with. This is just a snapshot, and we'll share it with you in the handouts following today's training. These are some of the mindsets we were asked to bring to the work. Practicing self-awareness, really pausing before we jump in and start a meeting to think about what are we bringing to this meeting? How are we showing up? Embracing complexity. Having a bias towards experimentation. This was a pretty hard one for me. I think as an attorney, just as a person, I'm a pretty risk-averse individual. And so through any sort of policymaking process, I'm kind of bound to be like, well, let's see, let's be cautious. Human-centered design really encourages to recognize that the systems as of today are not working and to have a bias when there is a choice point towards experimentation, towards something new, towards something different. These are just a few of them, but I encourage you to look through all of the samples and share these flashcards. You can print them and you can cut them up into sets of 6. I think there's about 12 or 18 total. Share them with your colleagues, look at them before meetings, and just consider a different way to facilitate. In the end, we tried to bring together these two unique but overlapping sets of expertise. The lived expertise of our National Advisory Council on Children's Legal Representation, which is the group that Cristal leads. 12 people with a personal experience navigating the child welfare system between the ages of 18 and 30 years old. These are the folks we were relying on to tell us, what do you need and want from your lawyers? What does the field need to do to be different? And who have the most creative and compelling ideas for how to reimagine what currently exists. But it's important to know, this wasn't done in a silo. We didn't forget that we also have a ton of subject matter expertise on staff, on our board of directors, and then in our national membership community. So we did multiple calls for public comment and tons of research to really make sure that we were synthesizing both the learned expertise and the lived expertise, and hopefully living in this yellow area in between of what we call liberatory collaboration. I'll turn it over to Cristal to tell us a little bit more about the process.
Thank you, Allison. Yes, throughout the process, we brought people together in different venues, a varied size of which varied in size of groups and expertise of groups. We had, like Allison mentioned, public comment. We had 2 calls for public comment. We had 5 to 6 NACCLR full group meetings. And during these full group meetings, we also had breakout sessions so we could have smaller group meetings as well. Throughout this process, we also met with the NACCLR one-on-one. I met with each person, had different interviews and talked through them through different questions. There was a document review and line editing throughout the whole process by Allison. There were also 3 to 4 NACC policy committee meetings where this was discussed. Where there was discussion and there was a call for feedback from them. There was also staff input and discussion throughout the whole process. And then ultimately the board of directors, outside of getting updates regularly, came down to the final vote. Next slide, please.
And before I turn on, just say it's important to see why we did this is to try to find various ways for people who communicate differently to access the process. And so, for example, we continued to hold our monthly meetings with the advisory council, which is, I said, a group of 12 plus staff, but some people aren't comfortable participating in a big group and gave much more deep feedback in their one-on-one with Cristal. Similarly, some people really like working on a Google Doc, giving edits back and forth and commenting, and for other people, that's not the way they learn or teach others. So there's a teaching point here about we're not just trying to tell you the process that we use, but also for you to understand when you're doing similar change making in your own organizations, to think about finding multiple pathways for people to give feedback multiple times.
Thank you, Allison. Here there is an example of how we got feedback. In the top, it's a little small to see, but in the green area, that's where we collected information like name, uh, gender, ethnicity, how they're related to the work. And then here at the bottom in the purple, we write exactly what we hear. We were told specifically and intentionally to write specifically what we hear, not what we think we hear, not summarizing the information, but exactly what we hear from the interviews that we had, whether it was group interviews or the small group interviews or the one-on-ones. And then in the pink, that's where we put like, what do we think that meant? What did we think that meant from what we were struck by here in the purple section? And then after in the blue section, writing what what can come, what change can come from the issues or challenges or stuff that people were saying throughout the interviews. We came back as a staff to make meaning of what was said here again in the pink section. And this was an area for us to really slow down and make sure that we were listening, we were pausing and making sure that we were interpreting the information correctly from our advisory council members. Next slide, please. And then here afterwards, we broke down everything that we heard into different themes. And then when we broke down the different themes, that was also an area to pause and ask our NACCLR members, is this in alignment with what you all are saying? Do you all agree? Is this what's being told to us? And then being able to also put here the supporting quotes, like what supporting quotes are going towards trust and confidentiality, listening, relationship building, and just making sure again that there was room for checking in for alignment and another natural pausing point. Listen.
So now, you hear about us going through this whole process, like what did we get out of it? And the answer is the NACC recommendations. This is a 30+ page document that you will receive in your handouts, that we've distilled all of that feedback we got, all of the themes that we got, into 10 main principles. So we're going to take you now through each principle, what it says, what it means for the field, and also recommendations we have about how to implement it. So we've established each of these slides into like the what should we hear from the advisory council about what they wanted to see, and the how is really the policy perspective and subject matter expertise of how to make that real, how to bring it to life. So let's kick it off with number 1, establish an attorney-client relationship. Attorneys for children and youth should adhere to an expressed interest model of legal representation. Overall, NACC had always stood by the ideal that every young person in foster care deserves a lawyer to represent them, regardless of the model of representation chosen by the state. In some places it's best interest or stated interest, or some places it's a hybrid model. During this process, here's some things we heard directly from the advisory council and from our public calls for feedback. One, that they wanted to be meaningfully and effectively engaged directly, that they didn't want their advocates to rely solely on others to formulate a position. But we know that should happen under any model of practice. Lawyers should be talking to their clients. They also wanted to feel a sense of autonomy and express that many aspects of the child welfare system and phases of it were disempowering to them. And there was an overriding theme of cultural humility that came through the process. Repeatedly at different phases, we heard from young people that they felt that views, norms, and morals of others were sometimes imposed on them. That is how we landed on shifting to very clearly establishing that an attorney-client relationship should use an expressed interest model of legal representation in order to combat those problems and ensure that a client's voice is directly transmitted through their lawyer to the judge. Of course, it doesn't mean that the young person's viewpoint always wins the day in court. Absolutely not. At the end of the day, the judge makes the final decision and hears perspectives from all parties. But we do believe that this is the best way to foster youth engagement and adhere to the professional rules of responsibility. Many of the recommendations under this principle track with the ABA rules of ethics. One thing that the advisory council really struggled with, as the field does, is like, okay, we get how to represent a 10-year-old or a 12-year-old or a 17-year-old under an expressed interest model of learning. But what about babies? What about toddlers who may not fully understand or even have the verbal capacity to interchange with an attorney in the same way? It was really interesting. The field has struggled with this question for decades. And I was pleased to see that the advisory council similarly wrestled with it. It's not like they just shot off an answer of like, oh, this should happen. They really wanted to hear about different models, different approaches, and be very thoughtful and intentional on how this could be well done. We researched and compared different ways states do this, ranging from a legal interest model to a best interest model to a substituted judgment model for infants and toddlers, and landed on the last one, substituted judgment. Happy to talk more in depth about this or do a training in a different day, but substituted judgment is what is called for under Rule 1.14 of the Rules of Professional Responsibility. And it is very close to a best interest model where the attorney is ultimately making the determination. But there's one difference. In a best interest model, the attorney is called to analyze the situation, look at the facts, and then make a best interest recommendation. In a substituted judgment model, they're required to take an additional analytical step, which is to put themselves in the shoes for the client and make a recommendation not based on what they themselves as the attorney think, but what they imagine that their client would want if their client could speak for themselves. And we thought that extra step was important, both to slow down and encourage reflection by the attorney. It also helps in the supervisory relationship for attorneys who are getting supervision or even peer support to really stop and think about, okay, let's go through this. Is this what coming from your own personal experience or what your client would want for themselves? Could they speak? Jean Coe-Peters is a scholar who has looked at this extensively and offers 7 questions that attorneys should ask themselves at each decision point when they represent nonverbal clients. And those are listed in the document as well. In order to create that information, regardless, attorneys should be extensively interfacing with collateral contacts, the child's parents, kin, daycare providers, any therapeutic providers, doctors, and coming from a starting place of family integrity, that we kind of assume that most babies and toddlers would want to be with their family if it was safe to do so. So all of that said, this is principle number 1, and it is one of the more distinct shifts among the 10 principles for us. Although NACC had previously endorsed an expressed interest model in various amicus work and other policy positions, this is the first time that we went from having a neutral position previously in the 2001 recs to a position that we're going to support lawyers for kids anywhere, regardless of model. But we will recommend that if you have a choice between 2, that you choose an expressed interest model of legal representation and leave it to others in the case, especially the clinical social worker, to make a best interest recommendation. Christelle?
Thank you. The second is supporting the attorney-client relationship. The what here is understanding the attorney's role. More often than attorneys might think, youth don't always have a clear understanding of what the role of their attorney is. There are so many people on a youth case. There's a social worker, a therapist, sometimes multiple social workers if they're with the agency, and just a lot of their resource parents, and their school teachers, and just so many professionals and so many adults in a youth's life. And so it's very important for an attorney to clearly state their role and help the youth understand what their role is in a developmentally appropriate way, as well as being able to establish the groundwork for what the other people in the youth's life's roles are as well. It's important to clearly explain that and let them know what an attorney has power over and what they might not have power over, what the youth can call an attorney for, or when the youth should call an attorney, and set expectations and boundaries around that as well. It's important to be mindful of language, and again, continuously check in for understanding. One of our advisory council members shared that they thought it would have been helpful to make an attorney's language more youth-friendly and not use so much jargon. They expressed that they used the word stupid for not always understanding what an attorney was saying. So it's important to make sure that a youth feels comfortable in asking questions. So both making it to where a youth doesn't have to overthink or feel that they don't know what an attorney is talking about by using youth-friendly language, but also making sure that an attorney is providing space for a youth to be able to ask questions and get clarification when it's needed. There's the follow-up and follow through building rapport. It's important to not overpromise to a youth of what you can do, or how often you'll be seeing them, or how often you'll be communicating with them. We think it's best if there's at least once a month checking in, a quick phone call, and a couple of face-to-face options with the youth prior to attending court. Many youth talk about only being able to talk to their attorney very quickly right before stepping into a courtroom, but there needs to be follow-up after court hearings, after team meetings, to ensure that a youth knows what it is, what the next steps are, what is needed from them, or just to have space to be able to debrief, what was talked about, what was decided upon, and why, and what that looks like. And through following up and follow through, there starts to be that building of rapport between the youth and the attorney, because the youth is able to see that they're able to trust the attorney. An attorney doesn't have a magic wand, and that's okay, but being able to really talk with the client and set expectations and be able to follow up and follow through when needed is very important. Using strengths-based language, youth are often reprimanded for kind of every little thing, to put it in very simple terms. And so being able to just talk with the youth and being able to tell them what their strengths are. There was an article that I wrote about my experience with my attorney and how he encouraged me to attend school and told me that I was smart and what a difference that made. And so youth who have really positive experiences with their attorney talk about the difference that it makes. And sometimes it's as simple as language, and being able to use a strengths-based approach with youth when working with them. There's a multidisciplinary approach. We think it's very important for attorneys to be able to work with peer advocates, be able to communicate with a therapist or the social worker, and really get a well-rounded view of what kind of support the youth might need, and what's going on, and how the youth might feel most supported. Again, it's important to have also early appointment, being able to meet with the youth as soon as possible when they enter the foster care system, and be able to talk through all the ins and outs with them as soon as possible. And again, following up to ensure for understanding. Allison?
Thanks, Cristal. One of the most interesting aspects of this discussion for me was about the time and place tailored to the client needs. So many times I would come to the group and ask them questions. For example, where should visits take place? And I know when I was practicing, I'll admit, it was not uncommon for me to visit my clients at school. That was my work day when they were in school, and it was off. I knew how to find them there, right? I could just stop by at any time and they would be there. But that was an approach that was centered around me, not centered around my clients. And so I asked, should we have attorneys visiting clients at school? And the answer is not an easy one. The answer is, it depends, or sometimes, or maybe. It's not always yes, it's not always no. Some clients really don't mind that at all. It's actually a place they want to be visited because they don't feel like they have confidentiality in their foster home. So they would rather see their attorney in school where they can talk more candidly without a fear that, the walls have ears. For others, they said, no, school is my safe place. It's where I don't want to be seen or treated differently or pulled out of class and miss more time. The point is, it has to be tailored to each individual client. And again, like Crystal said, that we're suggesting monthly contact, which is for, maybe you're listening to this and you're like, I already do that. Great, keep doing that. But there's a lot of places in this country where monthly contact is not the baseline expectation, and it needs to be. So we acknowledge that doing more frequent contact and tailored contact is going to take more time. And to address that, we've talked about caseloads in the next slide, later in the session. The next role is offering legal counsel and advice. This is principle number 3, and speaks to the attorney's ongoing and affirmative duty to advise children and youth about the legal process and their rights. Not just about the facts that are going on in their case or providing updates, but what their options are, and then to provide counseling on those options, not mental health counseling, but to really embrace the role of lawyer as counselor. There's so many people in a child or youth's life who's experiencing foster care. They often say people are in and out, there's so much turnover, what's the difference between person A and person B? Providing legal advice is one of the actions that no one else on the team can do. A foster parent, a CASA, a social worker, even the judge, none of those people is authorized to provide the legal advice and options to a youth that only the children's attorney can. And this is critical because what we heard from them is that they want to understand their rights, that many times they went through the entire system and it wasn't until they exited that they found out there was another option that no one told them about. So this is like a big piece to prepare them for whatever may come. For example, some youth spoke to permanency being described to them in kind of a directive way. Oh, aging out is a bad thing. No one wants to age out. You should sign these papers and do this guardianship or adoption. And many times that might be the right thing. But for some youth, for example, it did have legal ramifications in terms of loss of scholarship funding or other benefits or financial supplements that their caregiving family was receiving. That may or may not have impacted their choices and analysis. So they need to be fully advised of their options. In order to fully implement this, we advise that the out-of-court counseling role is just as, and perhaps more important than the in-court role for the attorney. And in some places, this is a big shift. I mean, there are still places in this country where attorneys are only even compensated for the time they spend in court for hearing time. And what we know is that if attorneys show up to hearings having spent no time out of court, it's not going to be a very effective hearing or a good use of judicial resources. Furthermore, there are so many advocacy opportunities between hearings that can help maybe mitigate the need for longer hearings to begin with. Family team meetings, IEP meetings. These are all places where lawyers should be showing up and providing out-of-court counseling about to the client and support. Like Crystal said, young people with lived experience have voiced that they want to be talked to without legal terms, but also with what I call trauma-informed candor. So let me pause here and just unpack what we mean by that. Candor, being honest with your client, telling them fully what is going on. In some ways, this seems very obvious. Of course, a lawyer should be candid with their client. But we have to acknowledge that, historically in this system, there have been policies, practices, and values that ideas that you should be shielded from some of the harshest information from their cases, and that it, quote unquote, would protect them from more trauma if they didn't know. What we heard through this process was really a disruption to that belief. People who've experienced said, I already know what's going on with my family, probably better than you do. And furthermore, voiced that keeping information from them further compounded trauma because it contributed to a lack of agency and autonomy and a feeling of voicelessness through an already difficult process. So we do kind of firmly enforce that young people need to be accurately and timely apprised of what is going on in their cases, even if the advocate might anticipate that this is going to be hard for them to hear. First of all, you might be wrong because they might already know it, or it might be good news to them that you think is going to be bad news. But then it's not just candor, it's trauma-informed candor. So we're not saying to do like a drive-by phone call. Hey, hey client, let me drop some difficult news on you about your mom or your dad's progress. Oh, I have to go into my next hearing, goodbye. It's not very trauma-informed. We'll talk about, education and trauma-informed interactions, and counseling and interviewing is critical. So that means making sure conversations are conducted in a setting that is calm enough where youth can really receive information, that there's an opportunity to provide that information to youth multiple times, sometimes with complex or difficult information. I know I need information repeated to me many times when it comes to complex legal decisions or anything like that. And also using strengths-based language and other trauma-informed interviewing techniques. So there's no shortcut here. We are saying no longer use the shortcut of just don't tell the youth if it seems hard. That is off the table. We have to do it the harder way, which is to have complete honesty with our clients about what is going on and offer that information in a trauma-informed manner.
Thank you. The fourth is ensuring opportunity for full participation, encouraging involvement and removing assumption. Allison spoke to this a little bit about removing the assumption that involvement is going to be harmful or traumatic. Youth have talked about it being more traumatic to have decisions made about them without them. And so encouraging involvement and removing that assumption is really important. You should be encouraged to attend court and to be involved in their case. Attorneys shouldn't assume that youth are interested, that aren't interested about being a part of the decision-making process of their lives. Our advisory council members have shared that missing school or other priorities have been seen as not wanting to be involved in their case instead of their wants and needs being considered. Some youth will have conflicting priorities and being involved in extracurricular activities and all of that good stuff, which we want to encourage youth to do and still be able to be a part of the decision-making process and very involved in their case. There's the autonomy piece to this as well. Very often in the foster care system, there's a lot of the decision-making power taken away from youth, and making decisions, being able to make decisions is a skill, and it's a skill that youth are often not provided the opportunity to really enhance, to really grow, and a lot of autonomy is taken away from youth. So being able to provide space for youth to be able to have and practice autonomy is very important. One of our advisory council members shared that even asking where they would like to sit in the courtroom and letting them make that decision for themselves was really impactful to them, to just be able to feel like they have the power to make decisions for themselves was really important to them. There's also avoiding, preparing the youth. Part of it of being involved and authentically involved is making sure that a youth feels prepared. So again, having that frequent monthly contact instead of, again, right before a court hearing is very important. That way a youth has time to process, to provide the attorney with updates on the progress that they're making, how they've been doing, updates on family visits, updates on what it is that they think might be best for them, and being able to build that relationship and talk with the attorney is also a part of preparing the youth. But being able to let them know what the courtroom is going to look like, being able to let them know who's going to be in the room and what their role is, to be able to prepare them about what's going to be talked about and why, and what kind of decision decision or decisions may or may not be made. So these are all things that need to go into preparing the youth to make sure that their involvement is authentic and meaningful as possible. And there's also being able to prepare the youth for being able to speak up in court. Some youth, like we mentioned earlier in the design process, some people like to give written feedback, some people like big groups, some people like small groups. So being able to also give them the chance to decide on how they would like to present themselves in court, if in any way. There's, being able to write a letter to the judge, or being able to speak up, or, being able to know the questions that might be asked of them so they can prepare their answers and feel comfortable saying it in front of folks. And then also avoid depersonalizing terms. This client, the youth that you're working with, is a human. And it comes back down to as simple as that. The youth that you're working with is a human, an attorney is human, the judges, the professionals, the parents, the family, the siblings, everyone, they're human. And so being able to really meet them as such, and being able to use their names in court instead of saying the parents, or, just avoiding those kind of terms, and being able to meet people where they're at is also very important. Yes, I think, and excuse me, yeah, and if there's any, just if there's anything else for a youth to be able to discuss, again, it's just really helpful to also, there's the preparation, but also the debrief to make sure that youth understand what they're saying, what an attorney is saying, or what the people in the courtroom are saying, and to be able to have space to digest it all. A youth may say they understand right after court, but maybe in a week or a couple of days, or at the next monthly check-in, completely forget or not really fully understand. So being able to give them the time and sit with them to be able to sift through all the information to ensure that it's all clear. Allison?
Thanks, Cristal. A few other tips that are provided in the recommendations regarding principle number 4, fully involving the youth. It also means in the written advocacy that occurs. So especially for older youth who are able, sharing the agency reports with them. They should be able to review before they come to court so that they're not surprised about what is going to be said. I think a lot of times the reports are shared, people are reading them at the last minute, and then everyone but the client knows what's going to be reported on. It's oftentimes the youth themselves, I know from my prior practice, who corrected the report and was like, actually, I don't go to that school anymore. Or actually, I did have a visit with my mom last week. It hasn't been 4 months. We actually just reconnected. So it can be both practical and part of full participation to share agency reports. Also, children's attorneys should be submitting their own reports or motions where it is, depending on local practice. And just like an adult client, having your client look at those before submitting to make sure they're factually accurate and reflective of the goals in the case. This also means including your client in all aspects of the court process. This could even be mediation in some places. But especially court hearings. So you'll see the second bullet point in the right-hand column says legal rigor if another party asks for the youth to be excluded over the youth's objection. What do we mean by that? It goes into further detail in the recommendations, but essentially all too often we have seen youth excluded from their own court hearings based on a proffer that this will be traumatic or something like that. Or if a youth does not want to be part of their dependency court hearing, they should never be mandated to do so, but it should be up to them to make that choice. It should not be based on a non-expert proffer that like this could potentially be hard to hear. A lot of things in life are hard to hear, and it can be more damaging to hear them later through a game of telephone than to actually be there and be able to ask questions in real time. So what we encourage here is to really scrutinize that process. If any party is asking for the youth to be excluded, that request go formally to the judge, and that the judge hear testimony about the potential harm to the child and not just accept it as a lay person's opinion that this could potentially be damaging. So this brings us to principle number 5, providing competent legal representation. And what does that mean? Youth want an attorney who communicates with them, but also one who's ready to take the case and has really the depth and breadth of specialized knowledge that is so unique and rewarding about the child welfare field. Young people we worked with in this process expressed that attorneys should have some initial training as well as ongoing trainings in various topics, as well as a much stronger grounding in cultural humility. Again, this is like another time where cultural humility was just like reinforced over and over again in the feedback we're getting. That's why you see it emphasized here. How do we get there? Well, the recommendations include a more exhaustive list of training topics that include federal and state law, various areas of social science, and some new topics. For example, human trafficking. We've heard from the Advisory Council that they didn't believe that the attorney workforce is trained enough on identifying the signs of trafficking in their client population. Competency also goes to your ability to do your job in terms of bandwidth. And so this is where we hit on that caseload recommendation I previewed earlier. NACC's prior 2001 recommendations included a recommended case cap of 100 clients per attorney. That is unfeasible. That is outdated. That is unworkable. We did broad national surveys on this. We did lots of feedback, as Christelle said earlier, and we've cut that in about half, recommending now a case range of 40 to 60 individual clients per attorney. So I say individual clients, not cases, because this accounts for sibling sets. Siblings have unique needs, so they should be treated like unique individual people. And we went with a range of 40 to 60 rather than a set number to really reflect what we heard, that there is still variation in the field, that practicing in an urban jurisdiction where your clients might all be within a few mile radius is different than practicing in a large rural jurisdiction where an attorney needs to drive 2 or 3 hours for one visit. That practicing in a jurisdiction that typically has full 45-minute to 1 hour review hearings as is best practice is different than practicing in a jurisdiction where a review hearing is 5 minutes or 10 minutes, and you may be able to take more cases, or where a trial can take place in an hour rather than in jurisdiction where a typical adjudication takes a day. So that is a big shift in some places. It's also not revolutionary. There are many law offices across the country that are implementing caseloads in this range. So as you take these recommendations to your own state, to your own decision makers, please don't bring 40 to 60 as an aspiration. This is being implemented in places and very successfully. It can be done. And some of that new Title IV funding can be drawn down to help do this, to supplement the work of children's attorneys representing youth, to hire more and make sure that their caseloads can ensure competent legal representation. And then finally, representation is not just enough. There needs to be oversight and accountability structures for the attorneys. That means different things, but youth from our advisory council expressed surveys, focus groups, neutrals like ombudsman, all different ways to be able to give feedback if they're not getting the quality of legal representation that they need or deserve. Christelle?
Thank you, Allison. Number 6, provide loyal and independent legal representation. Attorneys should be champions of their clients. You want to make them feel like they are somebody worth the fight, because they are. Attorneys should respect their client consistently, again, using a strengths-based approach, using strengths-based language when discussing their client and talking with them. It's important to help the youth feel empowered. Engaging them can and does lead to youth empowerment, and the language that attorneys choose to use when discussing when having conversations with their client and discussing their client in front of others is another way to also empower them and build that relationship with them. But being a champion for them and making sure that a youth feels heard and like somebody is fighting for them is very important. Sibling relationships can be tricky sometimes, and people with lived experience have shared the complexities that brings to families. Discussions, one of the one of the recommendations around representing sibling groups is ensuring that there are separate conversations with siblings instead of having them fully in one room. Folks shared their experience about being the oldest and feeling like they had a lot of power over, what was going to be, what was ultimately going to be decided, which can be a lot of pressure in the long run, but also during the process, and vice versa. Some siblings have different loyalties or have had different experiences with parents or with their family. And so it's important to see things through all different angles and perspectives and be able to see what best would be supportive to both the individual and what would be supportive to the family. So it's really helpful to have those conversations separately and to ensure that, again, there's all perspectives that are being heard if there is a sibling set involved. There's comprehensive investigation, which involves exploring the client's cultural identity. This includes, but is not limited to, foods that they like, the music they're interested in, the way they dress, their religious practices, and family traditions, to ensure that an attorney is advocating for these needs and these wants of their client, making sure that that a youth is able to go to the services that they would like to, or choose to not go to services that might be had by might be attended by the foster parent or resource parents that they live with, so that they can stay true to their beliefs and their traditions. So being able to ask this is all part of really truly advocating for their client. There's also making sure part of the sibling relationships is grappling with the potential conflicts of interest. So seeing, what youth want and being able to be honest and transparent and think of the best course of action afterwards. And again, the robust investigation and the comprehensive investigation, it really goes back to also including a youth cultural identity that often doesn't get talked about. Now it is moving more towards people recognizing how important it is for a youth to be connected with their cultural identity. Before it was very, we got to take care of the big things, and people didn't see cultural identity as the big things, the safety concerns. But being able to feel safe and be seen and be heard goes far beyond some of the ideals that we previously viewed. And now it's making sure that a youth being who they are at the core is being advocated for along the process. Allison?
Thanks, Cristal. I talked to one of our members a few weeks ago, and she was telling us about advocating for her client to be able to have a quinceañera with her family. It's like a really important thing that maybe in the past wouldn't have been considered part of what the attorney does, but that was so important for the young person as like a milestone in their life, and they wanted to celebrate with their family. Even though there were safety concerns in that case, they were able to establish it with supervision so it could happen in a safe way and the family could create a happy memory together. All right, on to number 7, maintaining confidentiality. So this might be a controversial one, I don't know. But what we did here is that confidentiality is important. We had already heard this. The federal government has released guidance that explicitly notes that the confidentiality of the lawyer-client relationship is important for all parties, but especially children. Contrary to past notions, what if the attorney finds out something is unsafe and then the kid, they can't tell anyone, and then the child ends up unsafe. That's kind of a red herring. What the federal government told us in their guidance, which is so true, is that the confidential attorney-client relationship allows youth to, maybe for the first time, tell a trusted adult about a situation that without that may otherwise go unvoiced, that they may keep to themselves. Youth understand confidentiality, especially teenagers and adolescents. I used to work at a group home many years ago, and I saw firsthand that many of the residents living there knew very well what mandated reporter meant, and they would wait to tell what was going on to their attorney rather than their social worker, not because they didn't want to get out of an unsafe situation, but because they needed a moment to process the information in a confidential space so they could get that legal advice and then make an informed decision moving forward. It's not that it kept information hidden, but it allowed youth to actually process what was happening rather than what we all know and have seen happen. They share something and it begins an immediate domino chain, like reaction effect, where things got out of their control very quickly. It's a safe space. Additionally, we heard feedback during this process about not just confidentiality in the lawyer-client relationship, but that attorneys have an obligation to step up and better protect youth confidentiality overall, like including their HIPAA rights. And I thought that was feedback well given. The Parents Bar across this country, I think, has done a better job about making sure they're finding legal ways to protect protected health information when necessary, if it's not relevant to the case. Whereas sometimes it feels like for children or youth, it's like open season on their health and medical and therapeutic records. It comes from a good place. Judges and others, caseworkers, we all want to know information so that we can make the most informed decisions. However, what we learned about this process is that sometimes that appetite for more information is actually causing more harm than good because it disrupts the therapeutic relationship. Therapists have confidential relationships with their client to create that safe space so that clinical progress can be made. And if a client does not have that, or if they go to court and find out everything they just said to their therapist was just written up in a report and shared in public, they're going to not have buy-in to working with their therapist and working through trauma and trying to get to healing. It's not to say that clinical information about progress should never be shared or that important milestones shouldn't be shared, but there are ways to do this in partnership with the youth to get them to the goal they want. This, I think, is particularly salient in regards to Family First implementation. And Cristal is the first person who pointed this out to me. Everyone's very excited about Family First. I think many of us agree there should be a reduction of congregate care. But there's a big problem here in terms of the court oversight of these placements, which now requires frequent updates from the residential facility and the clinical staff about how the youth is doing. In our rush and our haste to get youth out of residential, which is important and we should do, attorneys also must vigilantly protect a youth's mental health privilege and make sure that the judge has the information they need about therapeutic progress in order to exit the youth. But that doesn't mean they need to know every detail about what the youth is processing in therapy. All right, that takes us to number 8, Cristal.
Thank you. Yes, number 8, advance equity in legal representation. We had an advisory council member share that attorneys should know the youth's religion, ethnicity, cultural background, gender identity, and sexual orientation, their language barriers, how youth of color and those who have immigration status navigate through the world. They shared that without this information, their care plan will cause more harm than good, because without taking these into consideration, how are they setting up the youth for success? So being able to really be mindful of a youth's background, and removing one's own bias about, what it looks like to navigate the world, what values, what beliefs are held. It's important to be able to really learn what that means to a youth. There should be knowledge about the impact of systemic racism and implicit and explicit bias. Attorneys must uncover what triggers their biases and do the personal work in order to develop a process that uses objective criteria to guide their advocacy and decision making. Some of this may not be done through a race equity training. Some of these need to be uncovered through the personal work of being able to uncover, again, those biases, what triggers that, and being able to put one's own values and beliefs aside to meet the youth where they're at, and for who they are. Attorneys should be knowledgeable about the impacts of again, systemic racism and how that may affect, may have affected and affects their client on a daily basis, and be able to acknowledge that with them and be able to figure out what kind of support might be needed. There's, again, avoiding inserting personal values in beliefs. Elevate equity as co-equal to other 9 principles. So being able to ensure that equity is at the center of the work that you're doing when you're working with your clients. Culture humility is a fundamental aspect of an attorney. an attorney's competency, attorneys should explore their client's identity. Again, some of them were mentioned a little bit earlier, but also really taking into consideration that a youth come from somewhere. They have family, they had an upbringing, they have traditions. And so just because they are they may not be living with people, they may not be living with their family or people of the same cultural background or identities, it doesn't mean that that should be cut out. And often in the foster care system, that is cut out. I know for me, I wasn't able to practice Spanish. Spanish is my native language, and so being able to advocate for opportunities for you to be connected with their identity as they grow older is really important, and again shouldn't be cut out of a youth experience even if they're navigating through the foster care system. Next slide, please. That brings us to number 9, and provide 360 advocacy. Attorneys should always ask if the youth feels safe. What does safety mean to the youth? Again, removing own personal values and beliefs about what that may or may not look like. There's some level of safety, that needs to be considered, but also psychologically and emotionally safe. Do they feel safe where they're at? Are they being treated? Are they being treated correctly? Are they being treated in a way that fosters healthy communication and being able to heal from some of the trauma that they've experienced? Some of that again isn't talked about because folks think that if they go into a foster home and they're getting their basic needs met, then it should be fine. But there's also other levels of safety that should be checked in about. Do they feel like they can go to their foster parent or resource parent if they have an issue, or the other professionals in their life that they're interacting with? And so making sure that an attorney is asking their client if they feel safe on every level, and if they have all of the things that they need. Being able to also build a youth up is part of it. Again, we talked through about using a strengths-based approach throughout this presentation, and it's really important again to make as much space for youth empowerment and building a youth up as possible. It's a lot of trauma happens to youth who are navigating the foster care system, and the way again folks are talked about, the statistics that foster youth here, there's so many odds stacked against foster youth. So being able to utilize your role to be able to build a youth up and let them know that they can do it, that things are going to be okay, or are going to reach a point where a youth gets their needs met, and being able to facilitate that with them is really crucial to a youth experience. Being able to make sure that there's safety in a least restrictive environment. Like Allison was saying about residential homes, we want to make sure that youth are in family settings more often than not, and only utilizing congregate care settings when absolutely needed, and making sure that youth are getting out of those situations or that kind of environment as quickly as possible, so that they're able to have the support that they need and be able to have a sense of normalcy. And around normalcy, ensuring that youth have the opportunity to have normal activities. As a teenager, being able to go to the movies with their friends, or being able to have sleepovers, or go to prom, or go to the homecoming game, or to football games and stuff like that, making sure that that's being advocated for in court and checked in about. You shouldn't have to miss out on these activities because they're navigating the foster care system. There's a lot of rules and regulations again around safety, but there should be as much push as possible to have a youth feel like a normal teenager, a normal kid, whatever that means to them. So being able to discuss what that means to them, what that looks to them, what needs and wants they have around that is also important. There's also ensuring that there's client counseling regarding all permanency pathways and consequences. Some folks think it's the most important, or it's the best route to to work towards adoption or guardianship. That doesn't work for everyone. So being able to talk to them about what that really means, and what that's going to look like. And that way a youth has say with all of the information that's needed to make an informed decision. So making sure that attorneys talk through all permanency options is also really important. And to be able to talk about also, when youth are aging out, not having a conversation a week before their 18th birthday about, what services and resources are available to them, but to be planning and making sure that other people on a youth caseload are having the information, are having the conversations that they're needed to have in their role. We recognize that an attorney can't do everything in a youth's life. That's not the role of an attorney, but ensuring that they're advocating and making sure that the adults in the youth's life that are supposed to be supporting a youth in certain avenues are doing so. And lastly, holistic legal representation and safeguards against crossover youth, making sure that there is representation there well as well. Allison?
Thanks, Cristal. And on the last piece on the crossover, I'm happy to talk to anyone after today's training who has more questions. NACC really thinks that the children's law community on the dependency side can and should be doing more to prevent the pipeline to the juvenile justice side that we see, and that there need to be more policies in place to do this. So for example, we're seeing a movement nationwide to prohibit police from allowing youth to waive Miranda without their parent present. That legislation is being enacted on a state-by-state basis. Great. What does that mean if the state is your parent? Who needs to be called before the police can or should question a youth in foster care? How can their children's attorneys stick up and assert their Miranda rights for them? Or on a more basic level, the children's attorney is sometimes the person who can show up at the juvenile hearing or the delinquency hearing and really reframe what is going on in the case. We have a member who's currently practicing who recently related a story of a youth who's living in a group home who was written up and cited for throwing a piece of cooked pasta at another person in the group home over dinner, a piece of soft pasta. This is an action. I'm sure in my family, people have thrown a piece of pasta at each other a lot of times. When youth are living in family and outside system surveillance, these things don't get pipelined into a punitive system, but they're so much more likely to. And sometimes it's the children's attorney who can reinforce that, like, let's pause here and think about what we're actually doing and if this is needed or not and justified or not. Last but not least is principle number 10, preserving the continuity of legal representation. We did hear probably what many of you have already heard, that youth who have experienced foster care are frustrated by the high level of turnover in their cases, including caseworkers and sometimes the attorneys as well. Attorneys should endeavor to provide uninterrupted legal representation whenever possible, to proactively plan to be on their client's case from beginning to end. And that means a few different things. I mean, one, it means having relationships with others in the field, even if you're a solo practitioner, so that you can take breaks and that someone's covering the case if you are on medical leave or on vacation. But it also means taking care of yourself so that you can have a sustainable career in this field. So we do tie into principle number 10 that there's a duty of self-care to ensure that you can be in it for the long haul with your client. That doesn't mean, to always be there and have no boundaries with your client and to answer calls 24/7. Yes, clients want communication with their client, with their attorney. They want their attorney to be there for them, but they're also very reasonable. I haven't found many times the young people I represented were far more reasonable than many of the professionals and adults in the case. They will understand if you say, I'm available for phone calls between this and this hours, or I'm not going to be available on such and such a day, as long as you proactively let them know that. And we need to set up those boundaries so that we can stay in the field long-term and be there with them. Because it's oftentimes the attorney who is on the case the longest and serves that de facto role of like case historian. How many times have you been in a court hearing and you hear a service recommended or contemplated by a judge, and you can be the one in the case who says, actually, I think we did that with that family 2 years ago and it didn't work, and here's why. Maybe it needs to be revisited or not, but we know so much history gets buried over time, and being on the case in the long term has so much reward for the client. This principle already also speaks to records retention up to the client's 30th birthday, and some other specifics that I invite you to review after the training. So those are our 10 principles. Thank you for sticking with us during those. We're going to close with some just challenges and highlights about this process overall. The challenges, like I said up front, this was a time-intensive process. It took almost 2 years, about double the amount we had originally planned for. So we just have to acknowledge that up front. It was also a challenge for us to balance, like, what are our practical recommendations, the things that attorneys can implement today, versus what is a policy recommendation that's really doesn't belong in these recommendations, but maybe is more of a system change element. As I mentioned, we grappled with the infant representation piece quite a bit. And also that seeming tension between strongly believing that young people need to be treated as equal legal parties entitled to full due process, notice, and opportunity to be heard in their legal cases, with the simultaneous truth that youth are also different than other legal parties, that the unique aspects of the adolescent brain and their vulnerability in the case means that they deserve special protections, sometimes extra protections, than other parties in the case, and that there's a seeming tension there of treating youth the same as everyone else, but also responding to differences where needed. Those were some of our challenges, as well as from the advisory council, just the emotional toll of the process. We came to realize over time and heard feedback that, yeah, it was quite different for the advisory council members who were participating in this and we didn't ask people to share their personal experience, but of course this is going to recall memories for them of what their own legal representation was like, better or worse. The emotional toll that these meetings may have had on them is different than it may have had on me as a person with outlived experience. So those were some of the challenges. That said, we do think it was outweighed by the highlights. This was one of our first projects with the advisory council, and we think it really did generate a lot of trust and positive energy to start off strong. It got going through having this longer process with many avenues for feedback. It took more time, but we got more buy-in along the way and ended with a result that we think we have the most confidence that this is a realistic and equitable product that we're really proud to put out into the world. So what's next? Christelle?
Yes, thank you. So what's next? NACC encourages states and offices to adopt or amend policies to align with the 2021 recommendations. We are available to offer TA and support if you're looking to do that and would like support. NACC would likely use similar co-design strategies for future projects as well within our organization and with the NACCLR.
Thank you. So now we'd like to open it up for your questions. We have about 7 or 8 minutes. I see there's already one question in the chat, so I'll start there. And then I'll invite Robin, Alexis, or others to chime in with their questions. So the first question is, what duty do we have to represent the child client in school discipline, IDEA, delinquency, immigration, and other collateral proceedings? Great question. So this is a multifaceted answer. Whether or not you have an explicit duty to be the actual legal representative in that case will depend on the scope of your appointment order. So there are some jurisdictions where the judge fully appoints an attorney to do both the dependency rep and the education rep. I mean, that makes it pretty clear cut. You also have a duty not to take on legal representation that is outside of your competency. So if you cannot competently provide immigration representation, you should not be doing that. However, As I think it's principle number 8, 360 advocacy says, all of these collateral proceedings are cousins of dependency, close cousins. So what NACC says in our recommendations is that attorneys have a duty to be issue spotters on all of these collateral pieces. Do you have to be an immigration expert? Do you have to be a criminal law expert? No, but you have to be proficient enough to issue spot when your client is facing a legal issue, and then make the appropriate referral if you yourself cannot provide the recommendation. How can teachers and clinical psychologists work with attorneys to ensure the child's needs are met in the courtroom? Great question. I'm going to turn it over to maybe Christelle first, because she is a clinician and also has a background in passion for education. So Christelle, you want to take the first bite at that one?
Yeah, sure. I think that goes to like taking on a multidisciplinary approach, ensuring that a a teacher or a clinician, it looks a little bit different because the clinician will have different information from a youth potentially. So one, ensuring confidentiality. A clinician, part of their role wouldn't be to divulge a bunch of information that a youth has disclosed with them, but maybe instead providing guidance on what kind of support might be most helpful to bring up to a youth, or to be able to bring into the courtroom about the support that they might need. Maybe a little bit of the why, but again, not needing to divulge into a bunch of confidential information from the youth. A teacher, they're going to see the youth differently than probably anybody else. Teachers have a lot of interaction with the youth, so being able to talk about their personality, I think that's also helpful towards the strengths-based approach, because a teacher and a clinician might be able to see the solid strengths that a youth may have and what kind of support they need for some of the challenges that youth may be having in and outside of the classroom, maybe around relationship building, or kind of like how they're showing up on a daily basis, or they might be able to see how they show up after after a family visit or after a court hearing, or kind of anything like that. So being able to be in contact with these folks and asking the right questions, but also giving the right information and centering it around what would be the most supportive course of action for the youth.
Thanks, Christelle. And another idea I would add is in partnership with the youth, like writing letters. As an attorney, it was amazing to me to see how much farther I got. If I could report like, hey, I talked to the teacher and teacher X said that Susie needs A, B, or C, versus when it was in a written letter. I don't know what it is about the human psyche, but when something is written down, it just seems more official. And so talking to the youth about things they may need, if they want to. Some youth are going to want to confide in their teachers and their school staff, and being available for those conversations, but then not forcing it. Because like we said earlier, some youth want school to be the space where they don't think about their foster care identity. But if they're confiding in you and say, hey, I need a new winter jacket and no one has gotten me one in 2 years, or I need money to go on this field trip that I really want to go on. Keeping records of that, reaching out affirmatively to attorneys and being a proactive partner to say, hey, I want you to know what's going on, calling the attorneys. It is the attorney's job to get in touch with you, but it helps if you trigger that and say, I'm available, and offer to say, oh yeah, we do have this field trip, and this client really wants to participate in photography club and needs a camera. It's going to this sounds odd, but it's going to be a lot easier to get the agency to buy that photography club camera for them if there is a letter and support from the school, rather than just the attorney saying it as a request. So being available and providing letters where needed. Any other questions?
Oops. So while folks are maybe putting last minute questions into the chat, I am going to put in the CLE information, my email address, and just let you all know that the recording and the materials will hit your inbox tomorrow. And to give folks a little more time, I just wanted to say to both of you, I'm completely humbled by the incredible work that you do and this entire method of engagement with youth clients. I was a public defender before I started doing this, and my first placement was in juvenile. And it was a really incredible experience to learn that sort of advocacy, and how to deal with juvenile clients. I wish I had had this. I wish so badly I had had even part of this, to be able to really, do my best. So I hope that more people pick up on this strategy of interaction. I hope anytime that you want to do another training, I'm happy to send this everywhere. It was truly amazing to listen to you both. So I don't know if Robin wants to say anything.
I just want to make a quick pitch for the Florida Dependency Law Center. If you're not already a registered user and you're an attorney or a judge, I put the link in the chat. We would love to have you join. It's a great place to stay up with information and information about trainings. And thank you so much, Allison and Crystal. And I do see some other questions in the chat if you have time for them.
I think we're going to close there, but you do have our contact information. And so please feel free to email us. We will be happy to follow up. We're really passionate about the issue, and we look forward to continuing to work with Florida. Thank you all so much.
Thank you, everyone. Have a wonderful day.